Good morning. Welcome to a seminar on asset protection. I'm Attorney Joe Pippen, your host today. So we're going to get started. What we're going to do, so I'm going to talk for 30, 40 minutes probably, and then we'll take questions from the group. And we'll also answer questions on the chat room. So wave at me if you can hear me okay. Everybody hear me okay? All right, great. All right. So this is our second Zoom seminar. First one was about a month ago on estate planning. This one, of course, is going to be on asset protection. So I'm going to talk about various issues concerning asset protection that everyday consumers would need some knowledge or to learn about a little bit. Not everything I talk about will apply to all of you, but maybe you'll learn something from today's discussion about asset protection. First of all, the state of Florida has some great asset protection rules that apply to every Florida resident. That's all under Florida Statute 222. And what's Florida Statute? You can Google. I Googled this morning just for a quick, easy reference to Florida Statute 222. So you could just actually Google Florida Statute 222 and you'll see the whole statute, be able to read it. I'm going to talk about bits and pieces of it today. But what's protected from you, the Florida resident, is your homestead is protected. So every one of you have a homestead. Even your mobile home can be protected from a lawsuit and from being forced to sell and somebody take the proceeds from your home. So under Florida statute, every one of you, if you got sued, your homestead is a protected asset under Florida statutes. Also protected under Florida Statute 222 are insurance, annuities, retirement accounts. If you were to get sued and you were the head of a household, part of your wages are protected and cannot be taken away from you. So there are a lot of protections under Florida Statute 222 that apply to every Florida resident. And if there was a lawsuit, you need to take certain steps to protect those assets. I'll probably come back to Florida Statute 222 and talk about that a little bit more. But what is the most likely reason you'd ever get sued and then be worried about your assets? Well, for most of you and myself, probably it's a car accident. That could happen to any one of us. So automobile ownership is very, very important on just how you own the automobile. Now, I say that because if you're a husband and wife and you own a car jointly, and the car's in both names, you're both owners, well, guess who they sue when there's an accident? They sue the owner, which would be both of you, and they sue the driver, which may or may not be you. So they sue everyone they can, of course, and all of those parties are in jeopardy of being sued, the owner of the car and the driver of the car. So let's talk about husband and wife for a minute. If you own two cars, my advice is always to put the car in each of your names, the primary driver of that car. If that car is in an accident, they sue the owner and the driver. If the owner and the driver are the same person, they can only sue one. They cannot get to the assets from both of you. They cannot get to jointly held assets between husband and wife. They'd have to be able to sue both of you. So they can only sue one of you. They can't get to husband and wife jointly held assets. That's tenants by the entirety. That's a totally protected asset. So suppose they can sue both of you. Then they could possibly get all of your assets except the ones that are exempt under Florida statute. And I could go back to Florida Statute 222. If you have a visitor, down here in Florida, we tend to get lots of visitors. And if they want to borrow your car and you let them and they're driving, guess what? They're going to sue the driver, the visitor, and they're going to sue you, the owner. My advice always is to never loan your car to anyone to drive. It's just too much risk that anybody can have an accident. So it's too much risk that if you loan your car, then you'll be subject to the lawsuit because you own the car, they sue the owner and the driver. If you own two cars, put each car, husband and wife, put in the name of the primary driver of that car. If you own one car, I would put it in the name of the primary driver. Sure, both of you can be insured, both of you can have insurance on the car. Also, one way an asset protection theme is to have plenty of car insurance. Some of you might have 10/20 insurance. Well, if you get sued beyond 10/20, then they go for personal assets. They can get personal assets unless they're exempt under the otherwise exempt under the Florida statutes. So you might consider going to 100/300. You might consider having an umbrella policy over top your car and home insurance. Those are all just good planning techniques to avoid or a way to protect your assets and do some asset protection planning. You have plenty of insurance. How you own your car is very important. A lot of people have umbrella policies. They're not that expensive to have a little extra insurance if you have a car. If you have children or grandchildren even that drive your car and they have an accident, then you are the owner, so they could become responsible for, you could become responsible for that too. A lot of people would buy maybe an inexpensive car, put it in the child's name, or help get it put in the child's name so they're not liable for their child's accidents. That might be a good planning move. Let me tell you my very first conversation this morning, which deals with asset protection. It also deals with family law. So my very first call this morning at 8 o'clock was an existing client who had done a living trust with me, and she got married about a year ago. And her question to me is whether she can amend her trust to give her husband a life estate. She wants her new husband to be able to live in that home for life. So we got to talking about that. So what happens, they did not have a pre or post-marital agreement. They didn't have a pre-agreement. I think they're working now on a post-marital agreement. But here's why. She cannot just even though she owned the home, the wife owned the home, she wanted to give her husband the right to live there for life if she died. She cannot sign a deed by herself to put that in her trust. Why? Because the spouse has spousal rights. The spousal right is to be able to sell the home and take half the proceeds or live in the home for life. She just wanted to give him the right to live there for life. She didn't know about that he had the right to sell it, absent a premarital agreement, had the right to sell it and take half the proceeds. And of course, he would say he would never would do that. But sometimes he's not the one driving the boat. If the wife dies, and he was older, the wife had died, and the husband's, let's say, oldest child had the power of attorney, the oldest child could be driving the boat. The oldest child could make that claim against her estate, taking away from her children, and now using the power of attorney, he could benefit his father in this case and force the sale of the house and take half of the proceeds, which would be in the husband's side of the estate after the wife's death. So to avoid all that, this couple now is going to do a post-marital agreement. They're going to waive all of their statutory rights that they have against each other's estate. They're going to waive all that so they can each plan their own estate and leave their estate to their children and not their stepchildren. So all of this evolves around doing good asset protection and knowing what the rules and laws are, and then making an application or applying them to your own circumstance. So pre and post-marital agreements are very, very important. Otherwise, the spouse has rights, and if those rights are exercised, then you can lose a big part of your estate. So I encourage you, if you're considering remarrying, to consider a pre-marital agreement. If you're just learning all of this today, and some of this is fairly new to you, and you weren't aware that these rights existed and what your spouse's children might be able to do if you passed away first, well, you can do it like this couple is going to do a post-marital agreement. So it's very, very important to do planning. Even simple things like who owns the automobile is important. Make sure it's in the proper name so there's no lawsuits. It's very important to do pre and post-marital planning. Now, a lot of times, let's talk about asset protection in the way of avoiding probate. You
Mary
want to
Lou
work hard for
Duquan,
your
St.
estate.
John,
If you've
Florida.
created an estate, you have assets, you want to pass them on when you die to your family. You want to, maybe you want to give money to charity, your family, you have a whole list of beneficiaries, and you would like to maximize what you can get. You don't want your estate to be tied up in a court proceeding. So if you don't do the proper planning and your estate is tied up in a probate court proceeding, and every one of you that just have a will, or every one of you that have assets just in your name without a beneficiary, those assets are going to be subject to probate. Probate is the proving process of getting assets out of a deceased person's name. So to avoid probate, a lot of my clients do a living trust. And with a living trust, to avoid probate, you avoid guardianship, tremendous savings to your estate, more money for your heirs, more money for your charities, your children, your family, less money to the probate system of what has to happen if you die with an asset just in your name. Just as important to plan for probate is planning to avoid guardianship. None of you would want to, if I asked, well, okay, raise your hand if you'd like to be declared incompetent and become a ward of the court. Well, none of you would raise your hand, of course. Why? Because you don't know who wants to be declared incompetent. Nobody. But if you have a stroke or an accident or become ill and can't manage your own affairs and you don't have a proper plan in place, you subject yourself to a guardianship court. Someone has to be appointed to be able to take care and manage and control things for your benefit. And you want to avoid that if you can, and avoiding that would be doing a power of attorney, healthcare surrogate. Those are all important documents for you to have to avoid guardianship. Also, a living trust helps avoid guardianship because somebody's going to manage your money for your benefit in a lifestyle that you're accustomed to with a valid trust, power of attorney, living will. So estate planning is very, very important in protecting your assets for your benefit while you're living and to maximize what you can give to heirs and reduce the legal fees and court costs and so forth when you die. Now let's talk about asset protection from a slightly different angle. Let's talk about if you own a rental home or rental homes. What should you do with that type of planning? Well, if you own a rental home and you own it yourself individually, or even if you put it in a living trust, and I'm going to talk about next whether a living trust gives you any asset protection in a second, but let's talk about rental homes first. If you have a rental home and you own that individually yourself, or even if it's in your trust, and something happens on this property that causes a lawsuit, you could be in jeopardy. The jeopardy is a lawsuit would be filed against you, the owner of the rental home. So what a lot of my clients do that have rental homes is they create an LLC. They create a corporation, an LLC, and they transfer their rental home to the LLC. Now they've created a different entity. You and a trust, for example, are the same entity, same tax number. When you create an LLC, you create a different entity with a different tax number. You place your rental property in the LLC. If there's a lawsuit involving the rental property, then they can only sue the LLC. If the only asset in the LLC is a rental property, that's the only asset they can have a possibility of attaching or getting. If the rental property is heavily mortgaged, then there's not much equity there for them to pursue, and they might not even file a lawsuit. Usually they check out what the equity is and what they can get, and if they can't get much equity, sometimes they don't proceed with filing the lawsuit. If they can sue you, you have lots of assets to choose from, including the rental home and bank accounts and so forth, and they can sue you because you own the rental property, then a lot more assets are in jeopardy. So a lot of people will do an LLC for asset protection on rental properties. And so how many, if you own multiple rental properties, how many do you put in one LLC? Well, every client's a little bit different on that. If you had a whole lot of equity into one property, you might totally protect that and have that in one LLC. If you have lots of properties with no equity, you could group all those in one LLC and protect the ones with some equity. There are a lot of little strategy plans that you can do with LLCs and protecting your estate against rental properties. Can you put an automobile into a trust or a corporation? Well, yes, you could. That might protect you in some regards, but they still sue the driver. So would that protect you if you had a child, for example, that was driving your car and you didn't want to be responsible for the child's liabilities? Well, if the child is a minor or still living in your home and still a dependent, they might still be able to sue the parent. If you're letting a child drive one of your cars and they're independent of you, then they would still sue the driver, the child, and you, the owner. If the owner's a corporation, then and the child's not dependent upon you, then they might be able just to sue the child in the corporation, and the only asset that could be in the corporation would be the car. So you kind of limit your liability that way. All right, so people ask me all the time, does my living trust that I have, is that an asset protection document? Does my living trust protect me against lawsuits? The answer is no. A living trust has the benefits of no probate, no guardianship, quick, easy, fast, efficient, private, has a lot of great benefits, but you and the trust are the same entity. So because of you get sued, your assets that you control for your benefit, do whatever you want to inside a trust, do not really not protect you from lawsuits. Now, if you ask me, Joe, can you create a trust for me that would provide asset protection? The answer would be yes, I can. Do most of my clients do that? No, very, very small percentage would do what's called an irrevocable trust. So if you create an irrevocable trust, then you're no longer the owner. So that's why it would be asset protected, because now you don't own these assets. Could you derive some benefit from this irrevocable trust? Yes, you can get income only. You greatly restrict yourself in what you can do with the principal. So why an irrevocable trust would also avoid probate. Most people are not going to want to lose control of their estate, so most people don't create an irrevocable trust. They want a living trust. They want to own it, control it, do whatever they want to with it, avoid probate when they die, avoid guardianship if they become incapacitated, to have a private document that's not a matter of public record. Those are all great benefits. Almost every client I have, I'd say 90% plus, do living trust. It's a fancy will that avoids probate. Does it give asset protection? No. Are the assets that you place inside a trust exempt from creditors? Well, only if they're exempt under Florida Statute 222 that I originally spoke of, like your homestead. An irrevocable trust you create. Maybe you want to create an irrevocable life insurance trust. Maybe you want to create an irrevocable charitable trust. There are all different types of trusts you can create that you no longer own the asset, but derive some benefit from it that would be asset protected. So this whole world of asset protection, some of my clients will invest heavily in annuities. Now whether you do that or not depends on age and a lot of other factors, but an insurance, an annuity, and a retirement account are all protected under Florida Statute 222. And it's good to have some of your estate, your homesteads protected. If you're earning a wage and you're head of a household, a lot of the income that you earned, up to $750 a week, is protected from creditors under the head of household rules. So a head of household, where you have a dependent or a child or a dependent that you support, a lot of your wage is asset protected. Under this Florida Statute 222, there's a wage protection. There's a homestead protection. There's insurance, annuities, retirement accounts, pension protection. Your Social Security is protected under Florida Statute 22 from assets. Your disability payments are protected under Florida Statute 222. Nobody can take your disability payments, your wages. If you're a head of household, a lot of your wages are protected. A lot of asset protection things that I just think you should be aware of. And so that's why I'm doing this seminar, to kind of inform you of what assets you have are protected, and maybe give you some consideration, thinking points about who owns the car, who drives the car, what are my liabilities if the car's in an accident. Maybe you should increase your insurance. Maybe you should have an umbrella policy. Maybe you should be not let Florida visitors, out-of-state visitors that come to Florida to visit you, drive your car. Tell them to get a rental car at the airport if they're flying in. Don't give them your car. You're in jeopardy. And once you get sued and you're in jeopardy, you could lose a lot. Now, I've had many people call me right after an incident where they're worried about a lawsuit. Something has happened, and they have the fear that they could possibly get sued. And there are multiple reasons. This could happen in any number of circumstances. And then they start to want to move assets. They want to create a trust. They want to move assets. They want to purchase insurance that's exempt. They want to put more money in a retirement account that might be exempt. They want to do something to protect their estate. So there's, under the Florida Statute 222, if you go Google that and look at that, down at the bottom of that statute, you'll see all the chapters in each segment of that with what's protected. Down toward the bottom, you'll see what's called fraudulent transfer. So once you are concerned and once you have the knowledge that there is a lawsuit coming against you for whatever reason, and you try to move assets around to protect them, the exemption disappears if you make a fraudulent transfer. You shift it into a protected category. You make a gift of it. Somehow you maneuver, you learn what the rules are about what's exempt from creditors, and now you want to move it after you have knowledge you're probably going to get sued. All that can be undone under the Florida Statute 222 fraudulent transfer rules. Now, I also want to talk about nursing home and large medical bills and protecting your estate. So how can you do that? Suppose your spouse is getting ready to go in a nursing home, or your parent is getting ready to go in a nursing home. How can their assets be protected? Well, you certainly can't gift them away to family members, because gifting them would create a 5-year look-back period of disqualification from Medicaid. So gifting is really out of the issue, out of the question. You can do shifting assets into non-countable categories, and this would not be considered a fraudulent transfer. This is perfectly allowed under the statute. So the way this would work, a lot of our clients, we have a Medicaid attorney. His name is John Frazier. In fact, my next seminar in 2 weeks on Zoom will be with John, and we're going to do an asset protection Medicaid seminar. And by the way, if you're listening today and like to be part of that, you can just send us an email. You'd send that to Troy. Most of you had some emails from Troy about the link to this meeting. If you want to attend the asset protection seminar in 2 weeks, just send us an email, and we will be glad to accommodate you. But what can you do on asset protection from a huge $8,000 a month nursing home bill? How do you protect your assets so you don't have to, you can maximize government benefits? I'll go over that in much more detail on the next seminar, but one of the things you can do, your home is exempt. That's a non-countable asset to qualify for Medicaid. You can create a personal service contract where a lot of assets can be transferred into a personal service contract to protect those assets. They become non-countable assets inside a personal service contract. There are a whole list of other things, types of assets that you can put your money into that are non-countable to where you qualify for Medicaid. If your monthly income exceeds the amount of money where you would qualify, you can create what's called a qualified income trust, and that money gets transferred to a qualified income trust that becomes non-countable. So basically you rearrange your assets, so to speak, into non-countable categories so you can maximize the benefit you get on a Medicaid payment. And if you're paying $8,000, $9,000 a month for private pay on a nursing home, usually John Frazier can move things around so you qualify for Medicaid, and then you still have your legacy, your estate to leave to heirs. So you protected your assets, protected your assets by planning, and we can usually do all of this in about 60 days once a person Notice they have to go in a nursing home to qualify. Again, your homestead's protected. A personal service contract is not a countable asset. There are multiple other strategies to use on where you can put your assets that become non-countable in protecting your estate, maximizing what you can get from Medicaid, asset protecting everything else, and preserving your legacy. All right, so I think I'm going to go to take questions from the audience and also go to the chat room and see what kind of questions we have. Troy, if you indicate you want to ask me a live question, you can indicate that to Troy and he will unmute you. Or maybe you can unmute yourself if you have a question. I'm not sure, but Troy's monitoring this. So if you have a question, raise your hand or contact Troy here, or send Troy a message on the screen. And we will go to the chat room and answer a few of your questions that you posted today on the chat room here. All right, so, okay, so how long, the first question is, how long after my death is my living trust permitted to continue to exist under the successor and continue using my social security number as a tax number? Okay, so after your death, the trust becomes a different entity. And what I mean by a different entity is it needs a new tax number. And that's supposed to be filed for right away. So you no longer can use your social security number after death. Your trust is a different entity. And because it's a different entity, it would have its own tax number. So basically what would happen is that you file your final tax return you can file your tax return up to the date you die, and then a new tax return would be due under a new number, so the next year. So you die June the 30th, a tax return would be done under your social security number from January to June 30th. From June 30th on, everything would be reported under a different tax number, and the new tax return would have to be done. One of the questions here is just how about mortgages? So I'm not sure what exactly you want to know about mortgages, but a mortgage is not an asset, it's a liability. So mortgages don't disappear when you die. I'm not sure what the question is. It just says, how about mortgages? You kind of want to rephrase that and put more of a question to it. A mortgage is just a liability that doesn't disappear until it's paid. If you die with a property with a mortgage and an estate, then that mortgage still has to be paid by whoever receives that property, or it has to be sold and pay the mortgage off, and the beneficiaries get the proceeds. All right, so let's go through a few more questions here. If you are in an auto accident in another state, would the other state laws supersede Florida Statute 222 so that your assets would be at risk at the other state? All right, well, if you get sued in another state, they just get a judgment against you. That judgment would be a lien possibly on any assets that you have. So it doesn't matter where the accident happens. You might be sued in the other state, but the judgment against you can be filed in Florida and become a lien on Florida assets as well as any other assets you own anywhere else. So Florida Statute 222 protects you, the Florida resident, about lawsuits in Florida. If you get sued because you're driving in another state, hopefully you don't have assets in that other state, but the judgment could come back to Florida. You're still protected. If the question is, are you still protected under Florida Statute 22? If you're a Florida resident, yes. We have any live questions there, Troy, that anybody wants to ask me? No, okay. If you have a live question, you want to come on and be part of the Zoom program with a live question, I'd be glad to entertain those as well. Will a life estate protect assets? Is the next question I've got in the chat room. Okay, so if you change your deed from you to you with only a life estate, which means you don't own the property, you just have the right to live there for life, and then you get sued, they cannot take the property from you. And by the way, if it's your homestead, you wouldn't need to do this anyway. But let's suppose you have a second home, for example, and you deed that from you, the owner, to you with a life estate with the remainder to someone, and someone sues you, can they force the sale of that property? And would they be, does that asset protected? Yes, because nobody's going to sue anybody that just has a life estate, because the minute you die, there's no value and it passes on to remainder. So the little short question here is, will life estates protect assets? Yes, there is a form of protection there because you have no ownership the minute you die. So anyone suing you is not going to sue you only if you have a life estate, because there's nothing there to get. And Michael Satterley says, I have a comment I'd like to bring up. So then Michael, we can unmute Michael, and he can be free to ask me if we can do that. All right, we'll try to find Michael here, or Michael can unmute yourself and you come on and ask me a question live if you want to.
Hello, can you hear me, Joe?
All right, there's Michael there, but I don't hear him.
Can you hear me? Okay.
All right, let me see. Okay, so I'm not hearing Michael, so.
Hello?
Okay.
I hear Michael. Michael, you're coming through at least on the rest of the group.
Troy is gonna see if he can hear Michael on his computer, but not mine.
All right, well, basically, if you can relate it to Joe, the comment I wanted to make, he took a call last week from a gentleman on the radio that kind of scared me.
Okay, go ahead. Okay, start over because I can hear you now.
Okay. What I wanted to bring up, Joe, was you took a call last Sunday on the radio, and it, quite frankly, kind of scared me, but I just wanted people to know. The gentleman said that he was going through a divorce, and he received a large inheritance from his parents. He then made the mistake of putting the money in a joint account instead of starting one.
Yeah, I remember that call. Yes.
So, yeah, I just want you to talk a little, because people may not think about that, but that's kind of scary, that a little mistake that you might not even realize that you're making can turn out to be a big problem.
All right, well, that's, thank you for bringing it up. That's a great question. So a gentleman received an inheritance. I guess he was happily married at the time he received the inheritance, put all the money into a joint account. And his question is, does he have anything to be concerned about? Well, the answer is yes, because you turned your inheritance into a marital asset by putting it into a joint account. So now your wife's probably going to be able to get half of that. And I think from the way the question sounded was the wife wanted half of that. So the thing is, with an inheritance, if you keep it separate, just in your name, the one who inherited it keeps it separate and can prove, I got this inheritance check, I created this account just for this this money, I put all this money, I even do trusts once in a while that are called, like the Smith Inheritance Trust. So they'll put all the money they receive from their inheritance into this one trust. They've always kept it separate. They've never commingled it, and it's not a marital asset subject to divorce, a split, a proceeding under the divorce court. This gentleman, my producer actually felt sorry for this guy after the call, because that was such, I can't always give good news on the radio. I wish I could, but sometimes the answer is upsetting to people, and the upsetting answer there was that you made it a marital asset by putting it in joint names. So thanks, Michael, for bringing it up, though. I do remember that question very vividly. I also remember very vividly the question I got about the guy who wanted to make a citizen's arrest and go arrest the mayor who authorized a sanctuary city. And that was one of my entertaining calls, I think. All right, well, just send a note if you want to ask a question like Michael there and be live. I'll go back to the chat room. Okay. All right, so the question from Lee is, I have a second house in Florida that friends live in. It's not a rental property. Should I put it in an LLC? Well, it's might be advisable, because if they fall, your floor is uneven and they trip and fall, something you should have knowledge of that was fixed or not fixed, you might be liable for. You have an uneven sidewalk out front and they trip over that and hurt themselves. You have a rotten step on a porch outside or something. There are tons of reasons why somebody could get injured on your property and they could try to hold you responsible. If you have plenty of insurance on your property, you might not need an LLC, but what's the definition of plenty of insurance? You never really know what you could be sued for. I would certainly consider it. You can also certainly try to do, these don't always work, but trying to get in some waiver of responsibility of any liability issues that happen because they are a guest. They're not paying rent, but they're a guest. A guest on your property can sue you almost just like a renter can. All right, so somebody says my little story that was funny. I'm not sure which one was funny, but about the citizen's arrest probably. See, we have some more chat questions here. My spouse is a disabled veteran who has a fiduciary. Can we still put her assets, house is in her name, but bank accounts held by fiduciary or still has the spouse's name on them into a living trust? I'm the beneficiary of the estate. Well, I think anyone can create a trust even though the property is managed by a fiduciary. And if it's a joint account, it can be a joint trust. If it's an individual owner account being managed by a fiduciary, it could be an individual trust. You're the beneficiary of the estate, so I assume that means you're a beneficiary of that account. The benefit to the person, there's a good question right in there that's not really stated, but here's the question. I get all the time, I have a bank account that's POD, paid on death. So if I have all of my assets in POD accounts, do I need a trust? And that's kind of a little side question based on me just reading this question. Well, a paid on death account avoids probate. But I tell most of my clients, well, that's not the only question though, because probate, the paid on death doesn't happen until you die. I mean, you die, someone walks into the bank with a death certificate, they're paid on death on the account, they're going to get the account, yes, probate, no. So the more important question is, most of us are going to become incapacitated for a period of time before death. And so with a trust, the managed can be managed for your benefit while you're incapacitated but still living. And that puts somebody in charge of your assets for your benefit, avoiding the guardianship court being involved, because now you have a plan to avoid guardianship and probate. Paid on death, nothing happens until death. Power of attorney, paid on death account with a trust, it can be used for your benefit while you're living. So and then there are certain things that are paid on death at banks that can't be paid on death, like your home. Your home can't be put in a paid on death account. Can you do a ladybird deed or a life estate deed? Yes, but a trust is better, I think, because the trustee can deal with your property and your bank accounts while you're living for your benefit. That's not a benefit upon a paid on death or a ladybird deed. Let's go to the beginning here. I have a friend that has a dad that she keeps at home and hires 2 caregivers to take care of him. She spends more than she makes because she does not want to put him in a nursing home. Well, that's not a question really, it's just kind of a comment. I guess the question would be, what should I do? Are there benefits that you could obtain? What I would probably do is have hospice come in and do an evaluation, because a lot of hospice benefits are Medicare benefits, and Medicare can take care of some of these costs that you are incurring without you having to pay for private care in a home. So whether he would qualify for a hospice, what we qualify for hospice could come into play and help you a lot there. All right, so we have a couple of, thank you for hosting this presentation. Thank you. Let's scroll down here and see if you have a question, just send a note here and Troy will alert me and we'll get you on and ask you a question live for the benefit of everyone listening. Live questions are just a little bit better in my opinion because you have a little two-way exchange back and forth. I just get a question, I'm going to respond to the question the best I can, but it could be a little better if you want to ask me to become part of the program and then people hear the actual exchange of the question and answer, and sometimes there's extra questions and answers as part of it. I heard some, okay. Okay, just looking for questions here. Got a bunch of people putting their names, okay. Okay, our 401k, 457B, retirement accounts, etc., protected against a lawsuit? Yes. If you Google Florida Statute 222 on the home page there, a list of all the different statutes. Statute 222 protects retirement accounts. And that's under Statute 222 point, I've got the whole statute right here with the outline of it. 222.2022. Some other things while I'm looking at this, some other things that are protected are medical savings accounts are protected. Qualified tuition programs are protected from creditors. Disability income benefits are protected from creditors. Certain wages, which I talked about up to a certain level, are protected from creditors. There's no exemption for fraudulent transfers, which I talked about a little bit. You can't hide assets after you get sued and not have that possibly overturned. Is a rental property, if a rental property is in a trust, is it titled differently if you have an LLC? Is the question. Well, if you have a rental property and did an LLC, you deed the rental property to the LLC, so it's owned within the LLC, and then you transfer your interest in the LLC to a trust, so the LLC avoids probate. That's the answer to that question.
We have a raised hand, Mr. Monteith.
Monteith.
Joe.
Yes.
Okay, thank you. Can you hear me now?
Yes, I can.
So I have a question. My mother is 82 years old, and she has a mobile home in Ellington. Is it worth going to a trust for her? She has 3 sons. We're all knuckleheads. I don't think there's going to be any problem. It's not a big value thing. What's the best way to address something like that?
Well, a mobile home, does she own the land underneath a mobile home?
Yes, she does.
Okay, a mobile home title is just like a car title, and a mobile home title doesn't go through probate. And the reason I asked whether she owned the land underneath is because the owning of the real estate underneath a mobile home would go through probate.
Okay.
So the question is, how much is the land worth and so forth? I'm not asking you to tell me that right now, but
I would say it's probably the land would probably worth $50,000.
All right. Well, it's just a decision. So a lot of people would do a trust because our minimum probate fee that we charge is $2,500. There's $400 or $500 in court costs, so you may be looking at $3,000 to probate a piece of land worth $50,000. And if you had a trust, there'd be no probate of the land if you put the land into the trust. So some people make the decision they don't want to deal with the probate court upon death, and they would rather, even on a smaller amount, do a trust for assets. So trusts are not just for wealthy people. In fact, I did a little segment on that on the radio. It's a trust just for a wealthy person. No, a trust is for anybody who wants to avoid probate, and the minimum fee with cost could be easily $3,000. So why not go ahead and do a trust and avoid all that?
Okay, that's what I thought. And at the same time, my wife and myself will probably be doing the same thing. I don't have a trust right now, and we're looking to do it. So I appreciate all the work you do. I listen to you pretty often on the weekends.
All right, great. Thank you so much. By the way, some of you might listen to either Saturday morning or Sunday morning. I do both. On Saturday morning at 8 o'clock, I'm on the local stations here in Tampa, or 570, 910, 860, 930. Saturday morning also on, I guess I have people from all over Florida here. So on Saturday morning, also broadcast, Jacksonville station picks up the program, and I actually broadcast from Jacksonville every other week. And every other week I'm in Tampa broadcasting. Saturday morning at 8 o'clock on multiple stations. The Jacksonville station is 600 AM on the dial. We broadcast in Sun City Center on 96.3 FM, in Haines City on 90.3 FM. So there we have multiple stations around Florida that carry the Saturday morning program. On Sunday morning, I'm on Fox iHeart Radio 970 AM. And right now I'm doing from 6 to 9 o'clock on Sunday morning on 970. So I just bring that up as you mentioned the radio show, but I enjoy doing radio. I enjoy doing this. This is almost like doing radio. And I get to talk to a lot of people, give out some advice, and get to listen to questions to help other people as well. The next chat room question is, I've been trying to get a mortgage. Will Homestead protect me if I do not pay? Well, there's one of these answers that is not, you're not going to like, because the answer is no. If you're not protected if you don't pay. A mortgage is a lien. You don't pay your property on Homestead, they're going to foreclose. Right now, they got a foreclosure moratorium, but sooner or later that's going to catch up with you if you don't bring your mortgage current. Let's see who's next here. If you have a live question, just wave your hand and we'll get you on. Okay, Mary Lou.
Yes, hi.
Hey, Mary Lou.
Hi there. I have a living trust. I think it was fulfilled probably 5 years ago now. And in it was not only my present home, but also a rental home. Well,
Yes.
a year ago, I sold the rental home. So how does that affect the trust, because the rental home is now sold? Does that?
Well, no, it doesn't matter, because once you create a trust, you have the rest of your life to put things in, take things out.
Oh, see, I really
So
don't.
it doesn't, it's like a bucket, I call it. So you can put anything in your bucket, you can take anything out of your bucket. It doesn't matter.
Oh, I didn't know that. Not too familiar with this trust at all. I paid $2,500 for it, and I have no clue as to what's going on. And I really should get with you and find out what to do with it.
Yeah. Well, I have a lot of clients tell me something like that. They were quoted $2,500 or so for a trust. So just to mention what my fees are, we have all flat fees. If you're a single person, a flat fee for a living trust, which includes a trust, a will, a power of attorney, healthcare surrogate, living will, deeding your property to the trust, the flat fee is $795. And if you're a married couple, the fee is $895. And all of those joint trusts, 2 wills, 2 power of attorneys, living wills, healthcare.
Well, that certainly is way less than what I paid.
All right. Well, thanks for asking. I'm glad to share that news. Good news for everybody. All right, do we raise your hand if you have another question? I'll just keep going down the chat room. Okay, so question is a minimum amount of cash. Okay, you mentioned Medicaid on nursing homes. Would this not be based on minimum amount of assets? Yeah, there are minimum amount of assets to qualify for Medicaid. If you're a married couple, the community spouse can keep the home, the homestead, non-countable. They can keep around $128,000 worth of other assets that become non-countable for the Medicaid calculation of whether you qualify and keep a car. If you're a single person, your home still doesn't count against you, the homestead. The amount of money is down to $2,000. But we can move the money into non-countable categories. So we can move all of your home doesn't count, so you don't have to move that. You had more than $2,000 as a single person, we can put most of that into what's called a personal service contract. That becomes non-countable. You can still qualify. If your monthly income disqualifies you, then we create a qualified income trust to capture that, so you qualify. So there's not much we can't do to still have you qualify and protect your asset. everything we do is authorized by statute and disclosed to the Department of Children and Families in the application to Medicaid. So it's all legit. It's just standard statutory planning that we do to help a person maximize what they can save for their estate and qualify for Medicaid. All right, our bonds protected under Florida Statute 22, and they can be gifted to eliminate taxes. Bonds are not protected as far as asset protection goes. I mean, that's an asset that you own, just like a checking account or a stock or a bond. And can they be gifted to eliminate taxes? A person can gift up to $15,000 per person per year without reporting that gift to the federal government. And any built-up income inside of that bond you'd have to still pay a tax on that. So the next question. So when you collect on, let's go to Robert Paul.
Morning, Joe.
Good morning.
Texted earlier with the question about the living trust. You said it becomes a separate entity upon death. Is the successor trustee still required to follow the instructions?
Oh, absolutely. Successor trustee has a legal duty to follow the instructions inside a trust.
The other question I wanted to ask you, with respect to assets once you qualify for Medicaid, if you still have a mortgage on your homestead, does the monthly income that's used to pay for the mortgage, taxes, insurance, is that subject to eliminating your eligibility for the Medicaid?
Well, where does the income come from to?
Social Security and pensions?
Well, see, it doesn't, the extra income a person earns can be put into qualified income trust to make it non-countable, basically. So that would be the strategy. You still can qualify even if you have excess income over the limit.
Thank you.
All right, so let's see, I got some more questions here on the chat room. I have a second house in Florida that friends live in. Oh, I already did that. Should be put in an LLC, yes, okay. So when you collect on retirement funds and annuities, the income is protected. Is the entire amount protected from creditors? If it's more than income allowance of $750, it's $750 a week. So I mean, it's almost like $3,000 a month in income is possibly protected. Is the interest accrued on that money protected if you put the distribution into an interest-bearing account? Probably not. It's not, but your head of household, if you get a lawsuit against you and you're a head of a household, I definitely have an attorney file some papers for you to try to protect as much as you can. And you'd only have to be worried about the head of a lawsuit. If you have the lawsuit, they're going after your monthly check or weekly check. It's $750 a week you can protect as a head of household when someone else is dependent upon you. All right, so I think I've gotten, what is your fee for creating a living trust? I just went over that. If I personally got sued or all of my joint assets protected, all the assets owned between husband and wife, tenants by the entirety, are protected and can't be taken from you if only one of you can get sued. Next chat room question: to live in Florida, own a house in Massachusetts, home and husband and wife's name currently. If one of us dies, will it go to probate? If it's husband and wife, that's tenants by the entirety, so that goes to the survivor without probate. What should I do about the deed to avoid this? Or would be no probate. There'd be probate upon the second death. You can create a joint trust and put the property in a joint trust to avoid probate upon the second death, but there would be no probate upon the first death. I self-insure my home. I do not have homeowner's insurance. What document would protect me if someone got injured here? Well, you're going to get sued, and possibly if something happens, you could get them to do, the most you could probably do is to try to get them to sign a waiver, waiving their right to sue you if you allow them on your property. Sometimes even when you get those signed, they still try to sue you anyway. So it's just a matter of the circumstances on each case like that. There's no 100% answer that would apply to give you peace of mind, basically. What do you charge for an LLC to be formed to protect rental property? We charge $750 to do an LLC. Let's see, I have other questions here. Okay, let's go to Mary Lee. Okay, I can't hear you. Are you on mute? You have to unmute yourself, or my team here. All right, hold on, I still can't hear you. You need to unmute yourself on your computer. Okay.
Okay.
Oh, there you go. Okay, now I hear you.
Okay. I've read that an income trust, a qualified income trust, is an irrevocable trust. Is that correct?
Yes.
Okay. I've also read that the beneficiary of that income trust has to be Medicaid.
Well, you only create a qualified income trust if you're trying to qualify for Medicaid. So your income all comes into the income trust, and the income trust pays out your patient responsibility. And then if there's money left over, if there would be money left over, that can go to your beneficiary named in the document. But the point of an income trust is to qualify so you do get on Medicaid right away. So your $8,000 or $9,000 monthly nursing home bill can be paid for by Medicaid, and your income goes toward your patient responsibility, whatever that is that will disqualify you. So a qualified income trust is well worth it to qualify you for Medicaid to start with.
Okay.
Otherwise, you don't qualify, but then they'd be dipping into your principal $7,000, $8,000 a month.
Right. Right. Okay. If it should be somehow that the money that's left in the income trust is more than Medicaid is paid out, can that go to your beneficiaries, or does the whole remainder in the trust have to go to Medicaid?
No, the remainder doesn't have to go to Medicaid.
Okay. All right.
All right. All right, so if you want to sign up for the Medicaid seminar, John Fraser is really the expert on that area, and he'll be with me in 2 weeks doing a Medicaid seminar. So if you want to sign up for that ahead of time, just send Troy an email and we'll make a little list started here for that seminar. All right, so I don't think I have missed any of the questions that you chat mailed me. But if I did and you want to ask me in person here, I'd be more than glad to help you with that. So if anyone has a question, that would probably be the time to do it. So if you ever had a lawsuit, definitely probably see an attorney, because some of these things you require some action to protect the assets you have, like your homestead. You have to do like an affidavit to state that that's your homestead and post that as part of the lawsuit. If you get sued and you're head of household, you need to be proactive in trying to protect your accounts with some legal documents. So if you get a lawsuit, you can't ignore it either, because if you ignore it, they get a default judgment against you, and they can use that joint default judgment to go try to collect assets. So there are lots of things you can do if you ever get sued. Definitely want to have a lawsuit protection with an attorney giving you advice, your disability payments, so a lot of your pay as head of household are protected, insurance, annuities, qualified tuition programs, medical saving programs. A lot of those things are protected and can't be taken away from you anyway. Your homestead's protected. You have a lot of protections in Florida. And kind of the thing is, they say that Florida's a great state to die in because you don't have income tax. There's no estate tax now up to 11.5 million. There's no Florida tax, and you have all of these elderly protection statutes in place protecting homestead, retirement, Social Security, things like that. So, okay, well, it's been anybody have a question for me? Because I'm getting ready to end the program. I'd love to answer your question if you have one.
Yeah, I just wanted to say there's a few of y'all that didn't rename yourselves, such as iPad, iPhone, private user. Two of y'all have called in with your telephone. If any of y'all that don't have your name renamed, or if you called in by telephone, make sure you send me an email so that we with your first and last name, so that we can.
Yeah, if you could name yourself now before we cut the program off, because the ones that attended, that we know that attended, get the free asset protection book. So, but we need your name to verify you were actually here today. So I see names on most of my screen, but if you haven't put your name on there, just rename yourself and give us a name so we'll know that who actually attended the seminar. And we'll start sending out the book sometimes next week. And thank y'all all so much for attending today. My pleasure.
Thank you.
Thank you.
Thank you. My pleasure.
Thank you.